Good afternoon to you. Today we are continuing Constitution class. Today we are starting Union Legislature, which consists of President, Lok Sabha, and Rajya Sabha. Article 79 to 122 in Part 5. Article 79 to 122 in Part 5 of the Constitution deal with organization, composition, duration, officers, procedure, privileges, powers, etc. of the Union Legislature. Thus, like the King of Parliament of England, we have a President in Parliament. The President is an integral part of Union Legislature, though he is not a member of either House of Parliament, for the simple reason that he is to summon and prorogue the sessions, delivers inaugural address, and may have to send messages depending on the circumstances, and finally places his signatures to authenticate the bills passed by both the houses of Parliament. So unless he signs, the bill cannot become an act. However, the peculiar thing about our Parliament is that unlike English Parliament, House of Commons and House of Lords, our Parliament is not a sovereign body. It is not a sovereign lawmaking body. A legislative authority of Parliament is circumscribed by the written constitution. No doubt we have the legislature has some privilege and Parliament authority, but the legislative authority of our Parliament is circumscribed, enveloped by the written constitution, which also provide for judicial review. The judicial review has been vested with the Supreme Court and High Court. The powers are further limited by the innovation of basic structure theory by the Supreme Court. As a result, the lawmaking powers of Parliament has greatly been curtailed. It appears that the Indian Constitution has wonderfully adopted the synthesis of English principle of parliamentary sovereignty and American system of judicial supremacy. We have combined both cabinet form and judicial review. Nevertheless, in our country, the courts have not been allowed to establish what is known as despotism by virtue of the powers of judicial review under Article 39. Our system of parliamentary government has been adopted according to British model with American doctrine of judicial review, of course, to a limited extent. That is the special feature of our Constitution. As we have already seen, Union Legislature consists of President, Lok Sabha and Rajya Sabha. The powers of President with reference to his legislative functions have already been discussed by us in the earlier class. Today we will see Rajya Sabha. Rajya Sabha is called Upper House and also Council of States. It is also called House of Elders because only those who have completed 30 years can become members of Rajya Sabha, unlike Lok Sabha where the age is 25. The maximum strength of Rajya Sabha is fixed at 250, out of which 238 are to be representative of the states and union territories, elected by a system of proportional representation by single transferable vote by the members of legislative assemblies. The distribution of members are given in Schedule 4 of the Constitution. And 12 members are nominated by President from among the persons who have achieved distinction in the field of art, literature, science, and also social service. At present, Rajya Sabha has 245 members, of whom 229 represent the states, 4 represent the union territories, and the members are nominated by President. There is no reservation for SC/ST, remember, very important from examination point of view. The seats are allotted to the states in Rajya Sabha on the basis of population. Therefore, the number of representatives varies from state to state. For example, Uttar Pradesh has 31 members, whereas Tripura has got only 1. Compare this with the USA, where all states are given equal representation in the Senate, irrespective of their population. For example, there are 50 states in USA and each state has 2 representatives for Senate. So they have got 100 members, 2 each from each state. The representation of each union territory in Rajya Sabha are indirectly elected by the members of an electoral college specially constituted for the purpose. This election is also held in accordance with the system of proportional representation by single transferable vote. Out of 8 UTs, only 3, Delhi, Pondicherry, J&K, of course for J&K, the rules are to be made, they have representatives in Rajya Sabha. Population of other 5 union territories are too small to have any representative in Rajya Sabha. We may therefore see that unequal representation in Rajya Sabha and the feature of nomination of members in the House of States is a contradiction to the federal principles of Constitution. A candidate for Rajya Sabha election must possess the qualifications of number 1, citizenship, number 2, above 30 years of age, number 3, must possess all other qualifications laid down by an Act of Parliament. The Representation of People Act 1951 held that a person to be chosen as member of Rajya Sabha from any state must be, remember, must be an elector for the parliamentary constituency which he proposes to represent. In other words, if I wanted to contest a seat from Uttar Pradesh, I had to be a voter in any of the parliamentary constituencies of Uttar Pradesh. Representation of People Act 1951 was amended in 2003, under which the requirement of domicile in the state concerned was deleted for election of Rajya Sabha. Election to Rajya Sabha, of course. Similarly, the amendment introduced open ballot system in the place of secret voting. This amendment was challenged by leading journalists, as you know, Mr. Kuldeep Nayyar, in 2006 in Supreme Court on the ground that the proposed amendment has violated the principles of federalism and the basic structure. Nevertheless, Supreme Court rejected the agreement and declared that India, though a federal state, but it is no part of federal principle that representative of the state must belong to that state. Supreme Court also clarified that the representative of each state only refers to the members and does not import any concept or requirement of residence in the state. Similarly, Supreme Court clarified that the secrecy of voting is not an essential feature of democracy as envisaged in the Constitution. In other words, the Supreme Court upheld the amendment made to Representation of People Act 1951, and as of today, Most important factor as of today, there is no domicile restriction for being elected to Rajya Sabha. In other words, any person who is a voter in any of the parliamentary constituencies in India can become a member of Rajya Sabha. With this, we will continue with Rajya Sabha and Lok Sabha in the next class. Thank you very much. Thank you.